Ready? I'm just checking my sound system in the back. We ready? We're good to go in the back? Perfect. All right, Ms. Womack, would you mind reading the public disclaimer?
Notice of the June 12, 2019 meeting of the Tennessee Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since September 18, 2018. Additionally, this month's agenda has been posted on the website since Friday, June 7, 2019.
Thank you. Now, if you'll call the roll.
Commissioner Jeff Diaz, Commissioner Rick Douglas, Commissioner Marsha Franks, Commissioner Diane Hills,
Here.
Commissioner Austin McMullen,
Here.
Commissioner Fontaine Taylor,
Here.
Commissioner Bobby Wood, Chairman John Grease.
Here. And so we'll, if another commissioner or two shows up, if the minutes will reflect that attendance, that'd be great. At this point, I'd like Commissioner Douglas to lead us in an invocation and then the pledge to the flag. Mr. Douglas.
Father, we just ask you, Lord, to be with us today as we conduct the business that you've called us to. Help us to be fair and efficient in what we do and take us home safely. In Jesus' name, amen.
Amen.
United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Let the record reflect Mr. Diaz is now here for the important part of the meeting. All right, next up is to approve today's agenda. Are there any additions that anyone would like to make?
Motion to approve.
Second.
I have a motion by Mr. McMullen, seconded by Ms. Hills, that the agenda be approved as presented. I do have one addition I'd like to make sure we note.
We'll think about it.
Well, that's okay. I mean, I'd like to have a motion on the floor before we start discussion. All right, so we were to have a formal hearing tomorrow. The law department has arrived at an agreement with the licensee, and I would like for them to present as much or as little about that agreement as you want to hear before I sign a document. Okay, so I'd like to add that down to the legal portion of the agenda.
Motion to approve as amended.
Ms. Hill seconds that
Second.
motion. Any other amendments? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, next up is to approve last month's minutes. You may recall that meeting took place in Germantown. Mr. Diaz, do you have a motion?
Motion to approve.
Motion
Second.
by Mr. Diaz, seconded by Ms. Hills, that those minutes be approved as presented to us. Any corrections or additions, discussion? If not, let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Next up, we have a couple of medical waivers to consider, or medical waiver requests to consider. Rihanna or Anna, who's handling that presentation? They're pretty straightforward. Let's start with Frida Brody.
Sure. So before you, we have Miss Frida Brody. She is requesting a refund of the $100 late penalty due to circumstances. The statement that she has provided for you and her doctor's letter is provided on the iPads.
Motion to approve.
Second.
I have a motion by Ms. Hills, second by Mr. Diaz, that Ms. Brody's request be approved. And has that money been paid, do you know yet, or?
I believe it's been paid
So-
since it's a refund, yes.
Okay, it's a refund, then, okay. Discussion on the motion. Some of the questions I may ask today or may not be fair at all, may have to postpone them until next month, but is this going to become a regular event? I mean, we're seeing more and more medical waivers. Is there any?
I'm not sure. We just present them as they are given to us by licensees.
But in each case, when a medical waiver is presented or request for a refund or waiver of expenses, there's a doctor's letter attached or some justification besides just a request. Okay. All right, other discussion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ms. Kimball.
So we have Miss Lisa Ann Kimball. She is requesting a waiver of the $1,000 late penalty in addition to the waiver of testing due to financial hardship and family medical circumstances. Her statement is provided for you on the iPads. But prior to that, I would just like to inform you, if you'll look at the expiration date, her license expired 5/12/2018. And the medical waiver provision, just so we're all reminded, is found on page 80 of your red books in 1260-01-.21. Medical waivers can be presented before the commission. It's outlined in number 1, but number 3 states that a license expired more than 1 year. Then the individual must reapply for licensure, meet current education requirements, and pass all required examinations. So don't believe necessarily this would be a waiver that we can consider since it's past the 1 year mark.
Yes, Mr. Diaz.
Just a general question for him, Ms. Matlock.
Yes.
Is there anything in the statute that would allow us to consider taking care of a family member as a reason to waive fees and penalties?
Right. So it says because of the medical waiver, says if a licensee fails to renew within 60 days after expiration of the license because of personal or family health issues, it can be considered.
Pull that microphone forward.
Because she said that when she moved, she didn't change her address. It says that she didn't receive any notices. Well, we understand that. And I just feel like this is different than the case that we just heard. It's for lack of keeping on it more than having issues. So I would vote to deny it.
Make a motion to that effect.
I will make a motion to deny her medical waiver and refund of her $1,000.
Second.
All right, the motion offered by Ms. Taylor, seconded by Ms. Hills, if approved, would deny the request made by Ms. Kimball.
I'd just
Now-
like to clarify she hasn't paid yet.
She needs to be brought up to date in some way, or her license is expired.
Right. It's still an expired status. I just wanted, we're not refunding
Mr.
anything.
McMullen.
Yeah, in addition to what Ms. Taylor said, it's beyond the 1 year. So by statute or rule, there's not anything that I think we can do, as Ms. Matlock said.
And the only other thought I have, I thought if you got close to 12 months, the number was closer to $1,200 than $1,000.
It depends. It usually is right at 1,000 because the fees start. There is a 60-day, so you have 2 months taken off of that.
Other discussion. You've heard the motion. Let's vote. Those in favor of the motion to deny Ms. Kimball's medical waiver request, please vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Next up, and by the way, are we expecting anyone to show up from Cherry Investment?
No.
Okay, so let's move forward with it then. What's the topic here?
Okay, so we received an email from Mr. Jim Cherry. He is a principal broker, I believe, of a firm that is located in South Carolina, Atlanta, close enough. And so he is requesting a waiver of the zoning requirement. So he stated that he's in the process of moving to Hilton Head, South Carolina, And the zoning letter was waived in Atlanta because he's a commercial broker and he does not do the business in the office. But he went to the town of Hilton Head, and like other zoning authorities, they stated that the letter could only give the current zoning classification. And so he is unable to obtain the zoning letter that is required by statute, so he's asking for a waiver of the zoning requirement. There is no such waiver. I'd just like to clarify for the commission. It's statutorily required by 62-13-309 A1A and in the rules 1260-02-03-2. So we brought it before you because he wanted to ask the commission's point of view. And I'd just like to clarify that we're not asking, when we have a zoning letter, it's just that the individual's in compliance with the zoning ordinances of where their office is located. And he's unable to obtain that. And that's not something that you can require, because can waive, because it's a shall.
So he is going to have an office in the new location?
He's planning on having an office in Hilton Head, South Carolina, but in order to have said office, he would need to submit a zoning letter to the commission in order to change
Sounds like
his
he wants the
business
office to be in
location.
his home.
They won't give him a letter.
Yeah. Oh, the statute's pretty clear, isn't it, Anna? I mean, you got to have a zoning letter that says you can do what you want to do in there.
I think it's pretty clear. It states that you shall have a zoning letter turned in with your application. And there's really not a lot of ambiguity there.
Motion to deny.
Second. And then I have a question. It says
Sure.
escrow waiver.
It's supposed to say zoning waiver.
Okay.
This is for
'Cause
zoning.
I was thrown while we would look at
Yes.
the escrow waiver. Okay.
Okay, Mr. McMullen made a motion, and Ms. Hill seconded the same motion, which, if passed, would deny Mr. Cherry's request to waive the requirement that a zoning letter be presented with an application. All right, further discussion. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, any other waivers to consider this morning?
Nope, that's it.
All right, Mr. White, we're on high hum here, buddy.
Mr. Chairman,
Let's get your report.
members of the commission, good morning. We have a good report for you this morning. I'm going to present to you the June 12th education agenda for your approval. I have reviewed all the providers, the instructors, and their courses, and I find them in good shape and comport with the rules and the law. And I would submit to you J1 through J29 this morning for the courses.
Mr. White makes a recommendation to commission that courses J1 through J29 be approved. Does anyone wish to pull a course or two or three out before we consider that motion?
I do, Mr. Chairman.
All right, Mr. Diaz, which courses would you like to take out?
I'd like to briefly discuss courses J24 through 27.
Okay. Anyone else? If not, is there a motion to approve courses J1 through J29 with the exception of J24 and J27?
So moved.
Motion by Mr. McMullen,
Second.
seconded by Ms. Hills, that the courses be approved per the Education Director's recommendation. Discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Mr. Diaz, course J24.
Mr. White, you'll probably answer this pretty quick, but my concern with those classes is that how they speak to the law. I think how they speak to the law, especially some federal laws. Is this instructor and are the providers careful to make sure that they're not communicating to our licensees that they're able to dispense legal advice?
Yes, sir, Commissioner. And this is one of our national providers, the CE Shop, so they're internet courses.
Right.
But the provider and the instructor, Jill Malloy, comes very highly recommended with the background that she would need to be able to teach this course, and I feel confident that she would pass along your suggestion there.
What I'm worried about is that our agents are sitting down for these internet classes and there's no, I guess we'll call it a disclaimer or a notice that this course is meant to convey information for educational purposes, is not meant for you to use as legal advice towards your clients, et cetera. I'm just worried that our licensees might wander into dispensing legal advice without knowing it.
And I think your concern's well taken. Of course, we've had other providers with similar courses that we've approved with the same idea that they're not to go out and use this as in an improper way, but rather to help educate them on some of the elements of the Tax Cuts, the Jobs Act, and so forth. So I haven't found that there would be any concern with that the agents would take it the wrong way. Rather, it is for simply educational purposes for them.
Based on what you've seen of the courses so far, you're satisfied that due notice has been given to the licensees that this is for legal advice and they're not to dispense legal advice?
Yes, sir. Well, with our background here, we couldn't approve courses if we're talking about a strictly legal matter. They would have to have that background to be able to teach that course. But I think that Ms. Malloy has years of experience in this area, and basically in reviewing her material, she again comes highly recommended.
Thank you, Mr. Chairman.
Mr. Diaz, you want to offer a motion?
I will move to approve courses J24 through J27.
Second.
Is it through 27 or 24 and 27?
Through 27.
Okay,
Mr. Chairman.
J24 through J27. We previously approved 25 and 26, but for the record, let's go with the motion.
I thought he held out.
I thought he held out 24 and 27, not 24 through 27. That's
Anyway, I
it's,
think
yeah,
we're
we're going to handle it
them
right now.
Yeah.
We might approve some courses twice. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, what about the instructors, Mr. White?
Thank you, Mr. Chairman. I submit to you that we have several instructors that need to be approved, and I've included that information today with your instructor backgrounds. There are two parts to that instructor background. You might want to look over those. One instructor, Connie Niedergard, is on one by herself. There are four others on the other instructor background.
All right, commissioners.
Approve.
Mr. McMullen makes a motion to approve Education Director's recommendation regarding instructors in June. Is there a second to that motion?
Second.
Seconded by Ms. Taylor. Discussion. Mr. Diaz.
All right, I'm just reviewing Ms. Malloy's background that you provided to us.
Right.
And in her background, she's an experienced educator, I'll give her that, but she has a high school education and she does not have a law degree. Do we know if there's any more information about her educational background other than what you provided?
At this point, I'd just like to say I spoke with Ms. Malloy, and she convinced me of her understanding and background on her subject matter, but that she actually achieved her GED in Germany with her husband in the military. And I think she's quite a self-made person, but she has a lot of integrity with her, but also a lot of understanding. Just the conversation that I had with her. But she's not trying to dispense any information that I think would be improper or would not comport with the law and the rules.
It says she has a broker's license in Maryland and Virginia. Does she have a license in Tennessee? Real estate license in Tennessee?
Does not. I don't think that's a requirement.
Oh, no. Just from experience, and I did not have my license in Virginia, but we bought and sold a lot of things. Things are so different.
This is, once again, an internet course.
It is. She has her certificate of distance education instructor. She has all the credentials to be able to oversee and teach this course. It is a little bit different since it's an internet course versus a classroom course, I think.
So, I guess, does that mean she's composing the class, or is she voicing it over? Is it, what?
She's your basic, I guess, progenitor of the class. She's put the thing together. She works for CE Shop, but she's not present with when somebody takes their course. However, they can turn to her for questions about the course.
And I guess this is, just the how the sausage is made, so to speak, for these internet courses. Right. Do we have any visibility at all into the CE Shop? Like, when this class is composed, do they have a quality control process that before it's made live and available for sale to our licensees, do we?
Yes.
Do they evaluate the course?
We can actually review their courses and see them. I can do that. And I believe that the courses that have been presented are, again, they comport with our law and rules. But, yes, we have that capability. They have to give us the ability to review their courses when they're internet, distance courses.
Thank you.
All right, before we vote on the motion, Mr. White, I occasionally like to call out attorneys who use big words that I don't know. So why don't you define progenitor for me?
Well, the originator of the course.
Well, could you have used that word?
I could have done that, but progenitor just came to me, that old attorney thing, and
I got
yeah.
it. Okay, thanks. All right, the motion on the floor is to accept the Education Director's recommendation and approve educators listed.
Can we repeat who made and seconded the motion?
Austin made the motion. Diane Fontaine made the second. Any discussion, further discussion? Everybody clear on the motion? Yes, sir.
I have a question. Mr. White, I was looking at Rule 1260-0504, the qualifications for instructors, and there's part of that says that if the course concerns the law of real estate, the instructor has graduated from a law school that's accredited by the ABA or the State Board of Law Examiners. And I was just looking at the classes that Ms. Malloy is going to be teaching, and some of them, I think you could say, don't concern the law of real estate. For example, like Tax Cuts and Jobs Act, that's probably not really the law of real estate. Maybe sexual harassment law, that's not really the law of real estate. The other ones maybe do, Fair Housing Law, Fair Housing Act, affordable housing laws, things like that. Do you think that she would fall under that requirement, that she's teaching a course about the law of real estate, so that she would have to have graduated from a law school in order to meet the qualification for those courses? Or what's your thoughts on that?
Well, in looking over the courses and, again, in talking with Ms. Malloy, I didn't find that was what we were dealing with here. They weren't really, I did not think that there was any violation of our rule there. I really thought that she presents an overview. It is an internet course. It's not, again, with an internet course, a distance course, then they're not really in the same, it's not the same thing to me, but I realize that she has to have the credentials if she needs it. But for this type of course and the way that it's being presented, no, I did not think so. But I defer to you all, but I do not think that I think she meets the requirements. And again, I called her and spoke with her. because I wanted to just get her take on all this as well, and I was, I was convinced that these are fine.
Would we be walking a fine line, though, in doing something like this, according to Austin's interpretation of our law, our rule?
I defer to the will of the commission, but from my impression, Commissioner, these courses are fine to present. It is an internet course. She doesn't have the same one-on-one, in fact, that you would in a classroom. But even so, I didn't think that the courses would fall within that prohibition.
You're saying if she taught it in a classroom, you would think of her differently as to her qualifications?
I would want to know a little bit more about what's going on there, but I don't think you still have to look at the law and the rules and see that it comports with, that they're not doing something that goes outside that. So that's just my opinion. She's not.
Well, it seems to me that that's an interesting interpretation, that you would have to be a lawyer if you taught it in person, but not online. So
I'm not really saying that. I'm saying that the courses comport from the way that I understand it. After speaking with her and looking at it, I do not see that we have a violation or a prohibition that would require her to have that license. Now that's my take on it after my review. However, there are if we look back at all the courses that we've had over the years, I'm sure that this type of scrutiny we've tried to give to each course, and I have tried to do that. And so I've come up to this one, and this is the way I look at it. However, that is it's my prerogative to look at it and review it, and that's what I'm presenting.
Mr. Chairman, can I amend my motion? I'll amend my motion to approve the instructors, but with respect to Ms. Malloy, only approve her with respect to J27. That doesn't look like a real estate law class as I read the description of it. The other three, J24, J25, and J26, I think our rules would require her to have met that requirement, and I don't think she has. And so on that basis, and I don't know if maybe that's just on an instructor question, on a course question, but I'm okay with her teaching J27. I don't think it's probably appropriate for J24, J25, or J26. So that's my motion.
Second. Okay, Ms. Taylor seconds that amended motion. Is there further discussion?
Yes, Mr. Chairman. Mr. White, in your survey of the courses that are subject to the motion, is it your feeling that they are reciting statute only in those courses, or are they offering opinions on those statutes?
I don't believe she's offering opinions. She's just presenting the courses that have been put together, and through the CE shop as well. They present these to several states, the same courses. So, again, that's why I'm not seeing that requirement. However, I defer to the commission's will, and you will take that.
Let me just a comment. So the difference, in my opinion, between a classroom course and an internet course is, the curriculum is set out, and the only time you interact with Ms. Malloy or any instructor is if you have a particular question. So when I take an internet course for my continuing education in Kentucky, I've got the option of contacting the instructor, which I have never taken, which I think as an aside would be interesting to see how often that does happen on these courses. Mm-hmm. In a classroom course, in my experience, the course can go in any kind of direction just out of the clear blue, and that's where an attorney who's teaching law ought to be an attorney who understands it, because who knows what direction it's going in. On the internet course, it's fixed. You may have a question, but it's about this line right here. It's not like the course itself is wide open. And that's just a comment. It's not meant to sway anybody's vote on anything. But I do see the difference between the two courses. And the last thing I want to do, frankly, on an internet course is contact the instructor because it slows me down. I want to get the thing done.
Sure, well, the way you articulated that is exactly the same that the way I'm looking at this as well.
All right, other discussion, Mr.
I was just thinking about J24, taxes and real estate. I mean, I would think that even a CPA might be more qualified than an attorney to teach a course like that. So this is not, of course, we're not changing the rule, I know today, but this is a rule as opposed to statutory law, right? That this person would have to be an attorney.
It's in statute and rule.
It is?
Yes.
Okay. All right. So I guess the thing is to be able to define what the law of real estate is. And I don't know. It's fairly broad, I would think.
That's in statute, so that's not something that we can define in rule, unfortunately.
That's kind of where we're hung up here right now, I think, is trying to determine if this person who's teaching this is teaching something that is the law of real estate. And,
Right.
I mean, I don't have a problem with this person teaching all of these, but I'm just discussing.
So, in fact, the CE Shop is a national firm, teaches courses in every real estate jurisdiction in the United States. So if Mr. McMullen's motion passes, Ms. Malloy may not be able to teach 24, 25, and 26 courses, 24, 25, and 26 in Tennessee, but that does likely preclude her from being the instructor in 49 other states. It's not like, I mean, this commission's interpretation is pertinent to this state, but not to any other state. And I'm not, again, trying to direct this. I might vote with the motion, frankly, but I can see where it is an issue. Further discussion? Might not vote with the motion, too. I haven't decided yet.
Mr. Chairman.
All right. Yes, Mr. White.
Can I be heard just?
Sure.
Yeah, because the CE Shop is a national concern, then these courses are in Virginia, Maryland, and everywhere else. But as it concerns Tennessee, again, it's an internet-style course, and I don't feel that at this point, I serve at the will of the commission, but after reviewing it again, I don't think this is in any way violative of our laws. But I will take this and review future courses with this sort of overlay, this idea that for an internet course as well, that we'll be looking at that.
Clarification, just wanted to make sure that what you're saying is because it's an internet course, they're just conveying information that may have already been written by an attorney, right? There's no interaction that's taking place where they're going to be able to give the students opinion that might move them in the direction of the law of teaching the law of real estate.
That is correct. And
okay.
I think the chairman made that point as well. But I always look at things from a standpoint of, is this something that is going to need a Tennessee attorney versus someone that can just serve in the capacity as a question and answer person with an internet course? And so I could not see that here. And after talking with the lady, I was impressed with her as well. So that's, yeah.
Mr. White, our concern is Ms. Malloy teaching the class, or did she author the class? That's my concern. Is she the author, or is she just, was this assigned to her by CE Shop, but the class was written by a cadre of attorneys at CE Shop? Is that the arrangement, do we know?
Yeah, Commissioner, yes. These courses are offered throughout, not just in Tennessee. This is a CE Shop course. So they were put together by, I'm sure, a cadre of attorneys who drew these things up for mass consumption, and not specific to Tennessee, but rather a federal look. And then Ms. Malloy would not be in any way serving as an attorney. However, I can read the rules too, and I can see where you could conceive it that way. You could look at it that way. So I don't want to be seen to argue about it. I just want to say that it looked at, looking at it, it was in good shape to me.
Okay. Thank you.
Other discussion? All right, the motion on the floor, offered by Mr. McMullen, seconded by Ms. Taylor, would allow Ms. Malloy to teach course J27, but deny CE Shop's request for her to teach courses J24, 25, and 26. That's what's in front of us.
Bifurcate
You-
that
we
to
can,
use
we can,
another big
we
word
can
for
divide
you,
the question easily if you'd like.
and take the 27 on its own and then the other three by themselves.
Certainly, we can do it. However, would you like to
24,
divide the question?
Yes.
Let's vote on number 20. Is your recommendation we vote on J27 first? Right. Is that all right with you, Mr. Chairman? All right.
What you want to vote on? Why don't we vote on everybody else first, and then we just come back to just Miss Malloy. Got other instructors that are on the table too.
All right, so here's the order Mr. McMullen suggests. First, we approve the instructors that are non-controversial. Second, we go to J27. Third, we go to courses 24 through 26. Okay? All right, the motion on the floor is to approve all courses with the exception, all instructors with the exception of Miss Malloy.
Second.
Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no.
I abstain.
So the motion passes on a 5-aye, 1 abstain vote. Ms. Hills abstains. Now let's go to course 27. Mr. McMullen made a motion to approve Ms. Malloy to teach course J27. Ms. Taylor seconded. Is there discussion on that? If not, let's vote. If you're in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Next, Mr. McMullen made a motion to deny the CE Shop's request to allow Ms. Malloy to teach courses J24, J25, and J26. Ms. Taylor seconded that. Is there discussion?
It is only these are only internet, right?
They're all
Those three.
internet courses. All right, are you ready to vote? Everybody understand the motion? If you're in favor of denying the CE Shop's request to allow Ms. Malloy to teach courses J24, 25, and 26, please vote aye.
Aye.
If you're opposed, please vote no. No. So that motion passes on a 4-aye, 2-no vote. The chairman and Mr. Douglas voted no. Mr. White.
Mr. Chairman, members of the commission, the vote on Ms. Malloy, well taken, understood. But the courses themselves will be
Approved.
Well, they're approved, but they have no one to teach them. So,
Then you come back and ask us to get somebody to teach them, I guess.
so at the next meeting, I'll contact CE Shop and they'll have to come forward with but I want to be clear that the person they come forward with would have a law degree or that, yeah.
Based on what Mr. McMullen read into the record, I think that's pretty clear. All right. Now, Mr. White, I've got another topic for you.
All right, Mr. Chairman.
So you had an education roundtable since our last meeting.
It was well attended and
Please.
it was a great event, and I wish that our executive director could tell you about it, but I give her all the credit for putting it together and getting the folks here. But we had a roundtable, and we had about, I guess, maybe between 60, 70 total. We had folks in cyberspace. We had every one of these microphones had a provider, and they were able to tell the things that were most important to them, and it was a wonderful coming together, I think, of all, and the first ever that I know of, all the providers in the state. And they got to meet their peers, so there was that. But I'll just have to say, I hope we do it again and soon. We have a way now we can communicate directly with the providers, and I thought the information that was gleaned from it was really super. And it is available, I believe, still. We'd have to check with our IT folks, but there's a link you can watch it if you haven't. That think that was very well put together.
Well, I need more detail than that. I mean, were there a bunch of complaints from these providers?
There were no complaints. We discussed, among other things, internet courses, and webinars became a big topic of discussion. I think that's an underused format, and I think you may see some more webinar-type courses come forward. That was a topic. Of course, but there were no complaints that I recall at all. It was basically informational in that sense. But we discussed the P&P courses. We discussed the classroom style, and everyone here, I think, was very well received. Everybody was open. It was a good coming together. Commissioner Woods was here, and he sat with me up there, and we had several other folks that I think we're glad to see at least one of the commission here, and again, it was well received.
Well, if we'd had two commissioners here, we'd have a sunshine law issue. All right. As a matter of fact, I don't think we're invited to be here. But with that said, did you like to see eShop show up? Those kind of national providers, or were they online to participate? How'd that work?
We did not have CE Shop or McKissick or Kaplan. We did not have a representative for those, but for the most part, these were some of the larger Tennessee folks were here, including Trees. I think they were one of the first offers of real estate education in the state, and one of the larger providers. They were here. And representatives from other providers, the smaller ones and some of the larger ones as well. So again, I would just say that you might want to take a look at the version that we have now. I don't think it's on our website, but it could be sent to you, the link to it.
I'd like to take a look at that, I think, if it could be done. Any suggestions they made that are practical?
Well, there's just a lot of misinformation, a lot of things that would help me in as far as reviewing, and we're trying to just improve education in general. But I think that they felt that they finally had an opportunity to have a corporate voice, that we could all be together in the same room, and I could tell them some details that they needed to know. They needed to understand the law and the rules. That's something that I think a lot of folks go into this business without having really the understanding of it. And then our process. How does our process work? About the review, about the approval, about just what goes into that. And so the details of that were discussed. I wish everybody could have seen it. I think it was a good thing. I think we need to do it again, and hopefully that'll be as well attended as this one. Again, I give all credit to Caitlin Maxwell for putting this together first time, at least I've known it, that we've had such a round table. And so, yes.
Realtors send someone over?
I did not see anyone from the Realtors. I was looking for Steve, but I didn't see him. I don't believe he may have been online. That's a possibility.
My impression, they sponsor a lot of courses. I would have thought they might have had somebody here, but just a thought. All right, anything else, Mr. White, or other questions for Mr. White before we move to the next topic? Ms. Taylor.
Can the temperature be turned up some? I'm about to freeze over here.
What does that have to do with Mr. White?
It has to do with I'm going to shake to death.
Yeah.
I'll see what I can
and
do
Rick
about
need to change seats. Don't turn it up too much.
No. Well, you all need to sit here then.
I'm just going to turn it halfway.
Yeah, thank you.
Anything else, Ms. Taylor, besides that personal preference item?
No, I'll keep my preferences to myself.
All right, Rihanna, we're on to the Executive Director's report.
Information is provided on the iPads. If you have any questions, you can let me know. Caitlin has also asked that I let you know that the Arillo trip has been approved and that everything has been booked for the Knoxville meeting.
Good, good. It's actually a Farragut meeting. Yes, Ms. Taylor.
It's concerning to me that the testing, Tennessee Broker National, there were 286 tested, 145 passed, and 141 failed. That's real.
That many passed or that many failed?
It's 50.70% passed. That's not good. And the affiliate broker, 47%, almost 48% passed. Well, let's do it the other way. 52% failed. Now, this is concerning to me that something's not being done right if that many people fail a test, the national test.
But aren't you glad we test?
I am glad. Yes, I am glad we test, but it looks like we're not preparing. Somebody's not doing. There's some issues here. Is what I'm saying.
Well,
It kind of lands on the students, though, doesn't it?
or the
Or the courses or the classes or somebody.
I mean, I think if somebody wanted to research particular schools to see which school had the highest passing percentage, they can do that, right? You can.
Right.
And so, I think that helps put the pressure on schools to teach so that students can pass. I hope that's what it does. I mean, that was the intent. We will have to see. Anything else, Ms. Taylor? All right. Any other questions for Rihanna filling in for Caitlin today? We reserve the right to come back to you if something comes up we think about, okay? All right, at this time I'd like to take a 10-minute break, then we'll get into legal. Legal, I'd like to talk to you guys just for a second. And we'll get to the legal report. As you may recall, I added to the agenda legal's a little quick presentation by legal regarding the formal hearing we were to have tomorrow. Who's handling that? Kelsey, is Denard going to do that, or are you going to?
I'll do it.
Okay. So tell us why we're not having a hearing.
Back in February, two complaints actually were presented regarding an individual with a principal broker's license. They also had a firm license. This is a firm in Memphis. There was an audit request from late last year, early this year, that the respondent individual did not answer or did not want to cooperate with. That was presented to the commission in February. The commission authorized revocation of their licenses. So we were able to finally track them down and get them to sign an agreed order, which states that their licenses have been voluntarily surrendered, which has the same effect as a revocation. The order also provided for a $200 filing fee just to make up for our costs. So that was signed, and now it is before the commission for Chairman Grease's signature.
Earlier this week, I was asked to sign that agreed order, and I agree totally with legal that a voluntary surrender has the same effect as a revocation. However, in my mind, because there is a change, ever so slight, between what this commission authorized and what was negotiated, that I'm more comfortable signing that after this commission votes to say we're okay with it. So that's why I put this on here. Speak to the microphone.
Not only for the principal broker, but for his firm license, were both being surrendered?
Yes, it was both licenses.
And even though the voluntary surrender and is same effect as a revocation, when it comes to at some future point when they may reapply, would the commission look at a voluntary surrender differently than they would a revocation?
I don't believe so. I wish Caitlin was here, but it is my understanding that when we go into our license files, their status is going to show revoked, not surrendered.
Also, if someone was to apply because they have an order of something from the previous regulatory thing, it would say that this person has voluntarily surrendered their license, same as revocation. So if that came before the commission, that information and language would be there before you.
I move to accept the voluntary surrender of these licenses and to close the matter on that basis.
Second.
Okay, the motion made by Mr. McMullen, seconded by Mr. Diaz, if passed, will, in my opinion, authorize the chair to sign an agreed order that closes this case. Further discussion? Let's vote. Those in favor of that motion vote aye. Aye. Those opposed, no. That motion passes unanimously. Thank you for that. If you'll get me the appropriate paperwork, I'll be glad to sign that before I get out here today.
Okay, great.
Depending on how fast you go through your consent.
Well,
But that should not be taken as a reason to slow down.
All right, we're on to the consent agenda. Ms. Bridges.
yes. All right. Number 1 on the consent agenda is 2018-070091. Number 2 is 2018-090031. Number 3 is 2018-089691. Number 4 is 2018-091411. Number 5 is 2019-001701. Number 6 is 2019-002421. 7 is 2018-077631. Number 8 is 2018-077771. Number 9 is 2018-077941. Number 10 is 2018-078191. Number 11 is 2018-078331. Number 12 is 2018-078201. Number 13 is 2018-078871. 14 is 2018-088971. 15 is 2018-089551. 16 is 2018-088571. 17 is 2018-089971. 18 is 2018-089001. Number 19 is 2018-089721. Number 20 is 2018-089681. Number 21 is 2018-090191. 22 is 2018-090711. 23 is 2018-091721. 24 is 2018-091871. 25 is 2019-000411. 26 is 2019-000561. And number 27 is 2019-003121.
Is there a motion to accept council's recommendation and dismiss cases 1 through 27?
A second.
Motion by Ms. Taylor, seconded by Mr. Diaz. Now, Ms. Hills.
I have a question on
Would you like to pull some out?
14, 15, and 20.
14, 15, and 20. Okay, those will be removed from that motion. Other commissioners? Well, the chair would like to pull out number 8, 11, 12, and 21. And you can box 11, 12, and 21. They all have the same question. All right, other cases? If not, do we have a motion?
Yes. I have.
Okay, but it's got to be amended now to take out cases 8, 11, 12, 14, 15, 20, and 21. As amended. Okay, so that's out. All right, let's vote on the balance of the cases. If you're in favor of accepting council's recommendation and dismissing cases 1 through 27 with the exception of 8, 11, 12, 14, 15, 20, and 21, please vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, let's go with you, Diane. Number 14 to start with.
Really, 14 and 15 are together for me. So I'm just not clear when it says that they were in inactive status. And they were moving to another company. Was there just a day or two time lapse, or that part I wasn't clear even from the broker's answer?
I believe what happened was, yes, there's, some administrative steps that have to occur when you move to a firm. During those few days, there may have been a listing, or the broker had listings, prior to moving. So they transferred the listings to their new broker, and then once they moved or got their affiliation settled, I assume they took them back.
But it's usually very simple, is it not, to go online and do the transfer with a license?
It can be done online. Some people do it on the paper form. I don't know the details of this. I gave a lot of weight to the fact that this is a soon-to-be ex-spouse, and they did seem to be just filing this as retaliation.
Okay, I'm comfortable then. That's motion to approve. 14 and 15 both.
Is there a second to Ms. Hill's motion? Second by Mr. Diaz. The motion is to approve council's recommendation regarding courses 14 and 15. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. Motion passes unanimously. Now, number 20.
Number 20, and you may not recall, so did this firm begin, or this licensee begin with the lease, or they took over a lease that had already started?
That wasn't clear in the facts that I was given, but I believe that they were managing the lease the whole time.
As it was interesting, they signed the lease February 28, 2018, but they weren't licensed until March 22nd, 2018. And that was just the only thing that caught my attention.
Then you may be correct. It may be that they assumed management of the lease. That wasn't that timeline, or those details weren't provided in the complaint, and I didn't really even think to look for it.
Okay. Motion to approve.
Second.
A motion by Ms. Hills, second by Mr. Diaz. Of course, case number 20B dismissed per council's recommendation. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Now, number 8. I got the sense from the narrative that the agent didn't do anything to try to market this property. Is that correct?
It doesn't look like they made a whole lot of substantial efforts aside from hiring the photographer to go out and get video footage. But there were a lot of delays there as to why they couldn't get out.
It sounded like his whole or her whole argument was the fact that the photographer was delayed getting pictures, and so until she or he had pictures, she wasn't going to do anything, or he wasn't going to do anything to market the property.
I think that's an okay way to summarize it. I was kind of on the fence with this one, to be honest.
Do you think he or she put a sign in the yard, or do you have any idea about that?
They actually didn't mention the sign.
So what caught my attention was, okay, so you have a listing, and you don't do anything to try to market it, subject to a third party, I guess, subject to a photographer. I'm not sure that meets the requirement of...
And the dates I thought were awfully convenient, because I think it was the day that they said they were going to be able to get somebody to go back out was the day that they filed the complaint, and the same day that they wanted to terminate. I thought the dates were a little funny, and I do agree that it doesn't look like this licensee made very many efforts, but under the terms of the contract, they weren't obligated to take specific actions under the terms of the contract.
However, by statute, they're obligated duties owed to clients, like loyalty and obedience.
Right.
I would assume when someone signs a listing agreement that they now have a fiduciary, the agent, who's supposed to work in the best interest of the client at that point.
Right, absolutely.
And I don't get the sense that happened.
Yeah, like I said, I was on the fence with this one. I don't think that's an unreasonable interpretation of the facts.
Well, I don't have my...
It says you're supposed to diligently exercise reasonable skill and care.
You think, so I don't
Sounds
think.
like lack of diligence.
Thank you, Mr. McMullen. The chairs would entertain a motion on this if there's one that someone would like to make.
You've got the statute.
It's 4031.
All right, Commission, I'll take a motion. I don't care what it looks like. It could be to accept council's recommendation. It could be anything else, but I need.
Motion for 50 on my chart. 250, 6213, 4031,
Second the motion.
or 403, excuse me, just 403.
A civil penalty of $250.
Yes.
Any education you want to throw in there?
Yes, and who's our education person that knows our education?
Not here today.
There's an agency class, I just don't know how many hours.
The commission usually authorizes 4.
Like
With
that.
addition to agency or and 4 hours continuing ed that does not count towards the
Got it.
statute.
Mr. Diaz, are you okay with that? All right, so the motion, as I understand it on the floor right now, if it passes, will be to offer this licensee a $250 civil penalty, along with the requirement that the licensee take a 4-hour agency class within 180 days, and to be sure that 4 hours does not count toward any other continuing education requirement. That's what's in front of us. Discussion. Are you ready to vote? Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, now on 14, 15, and 20. It's my opinion that all those have to do with companies that promise to get you out of timeshares.
You mean 11, 12, and 20?
I'm sorry, 11, 12, and 21 is what I have written.
Or 11, 12, and 21, yeah.
My fault. I need to look at what.
We're on the
down.
same page.
And what was your statement again?
Each of these has to do with somebody complaining that a company who said they can get you out of timeshares failed to do so. Well, you know, our friends over at Consumer Affairs occasionally refer stuff to us. I don't know why we don't refer these three cases back to Consumer Affairs. It doesn't affect real estate, but it is obviously somebody's being, or feels like they're being defrauded.
I completely agree with you. I think that is a good matter for Consumer Affairs. There is a chance that they are currently open in Consumer Affairs. I know that with a lot of these, the cases or the complaints get duplicated. So we can double check, and if they haven't been opened in Consumer Affairs.
Let's just go ahead and be sure. I make a motion that we send 11, 12, and 21 to Consumer Affairs.
Second.
All right, you've heard the motion offered by Mr. McMullen, seconded by Ms. Hills. Is there discussion? Those in favor of that motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. That concludes the consent agenda. Ms. Bridges, how come you get stuck with all of these? You used to be.
I'm the only one you got left.
And if we don't treat you right, you may. All right. Case 1.
All right. Number 1 on the legal report is 2019-002001. Complainant is a property buyer and respondent, a licensed affiliate broker, was their agent. This matter is particularly fact-intensive, but in short, counsel believes the evidence indicates more likely than not that there is a violation of Tennessee Code Annotated 6213-403. Complainant was an out-of-state buyer. According to complainant, they relied on respondent to represent them at the final walkthrough and closing. Complainant alleges that respondent assured them that all repairs had been completed, but as soon as they moved in, they discovered the upstairs plumbing leaked and the property had termites. Complainant states there was also damage to their driveway, which they claim could have been prevented if a survey had been done, but respondent advised them that it was not needed. Issues continued to come up. Water began collecting in the basement, and then the HVAC completely went out, despite assurances that it had been repaired. Complainant also alleges respondent did not attend the closing and instead sent another agent in their place without notifying complainant. Respondent states they visited the property the day before the closing to check on the repairs, and note the parties negotiated a 32-item list. According to respondent, they informed complainant that some of the repairs were done, but they also observed other repairs that had not been completed. According to respondent, complainant was in a rush to close and told them not to worry about at least one of the remaining repair items. It isn't clear if they meant to ignore any of the other remaining repairs. Respondent denies advising complainant not to have a survey done and states they would never make that recommendation to a client. With regard to the termites, respondent states the seller provided a copy of the wood destroying insect report, which showed the property had been treated. Counsel notes that the report does state as much, but it also indicates live termites and structural damage with no evidence of previous termite treatment. Additionally, the report identifies multiple areas of the home that were not inspected because they were obstructed or otherwise inaccessible. As for the additional issues, respondent states they notified the seller as soon as each issue came up, and the seller took quick action to correct the issues. Counsel notes that the seller had their own broker in the transaction, but it appears respondent negotiated most, if not all, of the repairs to be completed just prior to and after closing directly with the seller. Based off of their text message exchanges, it appears that they are friendly and possibly know each other outside of the transaction, and there was one instance in which the seller asked for a brief meeting with respondent and instructed respondent not to tell their agent. Respondent agreed, but it is not clear if the meeting ever took place. Finally, respondent admits that they were not at the closing. Respondent states they had car trouble that morning and got stuck at another client's property, but they were able to secure another broker affiliated with their firm to attend the closing in their place. As noted above, this complaint involves two conflicting stories, but there are a few facts that are undisputed. Respondent was the only representative for the buyer present at the final walkthrough, and multiple significant issues remained with the property after closing. Additionally, respondent agreed to meet with the seller without the seller's agent's knowledge, although it is not clear if this meeting took place. In light of these factors, counsel recommends the commission find that the respondent violated their duty to exercise reasonable skill and care owed to all parties in a transaction. And then my recommendation would be for a $1,000 civil penalty.
Motion to accept.
Second.
Motion by Mr. Diaz, seconded by Ms. Taylor, that council's recommendation be adopted and this licensee be offered a civil penalty of $1,000. Discussion.
I think they need a course.
You feel free to amend that motion any way you like.
I'm like Diane, I don't know what the course would be. There's certainly,
Just make a statement about this. Often, more often than I would like to see, licensees, for whatever reason, decide to take the role of the seller or the client as opposed to saying, that's not my job. And so they get in predicaments like this. And they do it trying to be helpful. Well, helpful is not what you need on a final walkthrough before closing. You need somebody besides yourself who's going to take the liability or make the decision, whether it's a relative or a home inspector, but not the agent. So I don't know if there's a class that teaches that, but that's my message.
You could start teaching one.
No, I've probably made the same mistake at some point.
It's kind of the representation in a way. It's how you represent your client, which they're not doing if they're making the decisions for them. I don't know, but I don't know what class it would be. That's what I'm trying to say.
Maybe agency. I mean, unfortunately, this licensee allowed themselves to have this, took it on themselves, which is no good deed goes unpunished.
Well, and they went directly to the people and left the other agent out. There's a lot of
Agency.
they weren't doing their right. They were not doing their job right.
Mm-hmm. Agency's the only thing I can think of to.
Yeah, so the question is, was this licensee working in the best interest of his or her client? So then I think it's an agency at that point. So, Ms. Taylor, if we've gotten to that point, what would you like to make a recommendation of?
Take the, what is it, 4 hours or 3 hours of agency class, 4 hour, or whatever, the agency class within 180 days above and beyond that wide education. But I would say their broker needs to come on this one too.
We don't have a complaint at this moment open against the broker, so we can't handle that. You have that latitude coming up if you'd like to exercise it. But at the moment, Mr. Diaz, are you okay with adding a 4-hour agency course?
Yes.
All right, so now in front of commission is a motion offered by Ms. Taylor, seconded by Mr. Diaz, that if passed, would offer this licensee a $1,000 civil penalty and require that they also take a 4-hour agency course within 180 days of signing that agreed citation. And that 4-hour course does not apply toward any other required continuing education. You ready to vote? Let's do it. Those in favor of the motion vote aye.
Aye.
Those opposed, no.
No.
That motion passes on a 5-aye, 1 no vote. Mr. Douglas votes no. Number 2.
Number 2 is 2018-090951. Complainant previously rented a property managed by respondent, a licensed affiliate broker. Respondent also acted as complainant's agent in the purchase of their new home. Complainant alleges respondent improperly charged them rent for the month of January 2019, even though they vacated on December 14th, 2018, and a new tenant moved in the following day. Complainant also alleges respondent improperly charged them a 3% commission on the purchase of their home after complainant terminated their exclusive buyer agency agreement with respondent. In response, respondent indicated that the lease action has now moved into litigation, which is being handled by their firm's legal counsel. As for the commission, respondent stated that they typically include a carryover clause in their buyer representation agreements, but realized upon a second review of the agreement with complainant that they neglected to fill in the terms for the carryover provision. Thus, they are no longer claiming they are owed a commission and informed complainant as much. My recommendation is for litigation monitoring.
Motion to accept council's recommendation.
All right, the motion offered by Ms. Hill, seconded by Ms. Taylor, if passed, would accept council's recommendation and put this case into litigation monitoring. Is there discussion?
So there is litigation going on?
Yes, according to the respondent.
Respondent reply at all to this notion about leasing the apartment almost immediately and still charging the previous tenant a month's rent?
No, it was really just a brief statement that this exact issue is being litigated currently in civil proceedings.
Other questions, comments? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 3.
Number 3 is 2018-082571. Complainant states they entered into a contract which provided for access to discounted resort rates in exchange for monthly payments. Complainant states they specifically purchased the contract based upon the salesperson's assurances that they would be able to stay at a partner resort where complainant was already a frequent visitor. However, they discovered online that the resort is never available for bookings. Complainant states they have been making payments for over 3.5 years now and have never received the discounted resort stays they were promised. Notice of the complaint was delivered to the named respondent. Respondent denies any involvement in this matter and states they have no relation to complainant or the resort named by complainant. Respondent states they are a vacation exchange program for use by its individual members who own vacation interests at participating resorts. Respondent is not an agent of any developer and does not sell or manage timeshare or vacation interests. However, they did provide contact information for the party they believe the complaint should have been directed against, who is the respondent in the matter below. So for this one, I'm recommending dismissal and then disciplinary action for the properly named respondent.
Diaz makes a motion to accept council's recommendation. Ms. Hill seconds that motion. Ms. Bridges, so this is just kind of a general question. What does the Real Estate Commission have to do with vacation swapping?
Well, vacation clubs are regulated by the commission.
Are vacation lodge considered vacation lodging? Or what are they considered?
It's a vacation club. It's very similar to timeshare, but different. It's my understanding of vacation club is, I think, similar to this explanation that they allow for current timeshare interest owners to exchange their interest and vacation elsewhere. I believe that a vacation club does not have to be licensed, but the developer has to ensure that those timeshare interests have been registered. And then exchange agents don't have to be licensed, but they do have to provide an annual statement to the commission.
Mr. McMullen at one point pointed out to me, now I understand why we do timeshares, because they generally involve a mortgage and a warranty deed of some sort or another. But if somebody's just swapping, like an exchange club, I don't get the statute particularly call out vacation clubs?
Yes, if you would like, the definition of vacation club
Yes.
is on page 136 in your red book. I can read that for you. So a vacation club means any system or program with respect to which a purchaser obtains by any means a recurring right to use and occupy accommodations and facilities, if any, in more than one component site through the mandatory use of a reservation system, whether or not the purchaser's use and occupy right is coupled with an interest in real property.
Whether or not it is. Did the last sentence say whether or not it's included?
Whether or not,
Okay.
yes.
Thanks for pointing that out. All right, the motion on the floor is to dismiss. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. And motion passes unanimously. Number 4.
Okay, so number 4, so complainant is the same individual in the above complaint. Respondent denies complainant's allegations. Respondent states complainant purchased their contract on August 31st, 2016, and that they received and signed a truth in lending disclosure document. Respondent states that their rental program provides access to week-long condominium and hotel stays, and that complainant's preferred resort is available under the reservation system's hotel listings. Respondent stated they would be happy to reach out to complainant and explain the reservation system. Respondent also offered to waive complainant's outstanding contract balance, but leave their membership intact so that they can continue to use it through August 2019. Counsel requested a copy of the contract from complainant, but did not receive a response. Nevertheless, it appears respondent is offering vacation club interest in the state without proper registration in violation of Tennessee Code Annotated 66-32-207. My recommendation is for a $1,000 civil penalty. And I also just like to add, I don't think that it's necessarily the issue is that the vacation club interests weren't registered, and they may or may not be, I'm not sure. But it is clear that we do not have any sort of annual statement or any information about this exchange agent. So, $1,000 for unlicensed or unregistered, whatever you want to call it, activity.
What would you like us to call it?
A violation of 66-32-207.
Motion to accept council's recommendation.
Discussion?
I have a question. So in 1260-06-.09, the exchange agent, and it says they're supposed to file on or before every July 1st. So that's what you're saying, there's no record of for this,
No.
for exchange agent?
No.
No, there's no record, or no, she's wrong.
Oh, no, that there's no record.
Okay, thanks.
Okay. So so I'm assuming they've never filed, so we don't ever have them on the record. What happens to the people who then don't file every July 1st? Does it get
This is
called out?
a new issue for me. This is the first
Me
vacation
too, that's
club
what
complaint that I've seen, so I don't have the answer
Okay.
to that question.
Okay. This is just new for me.
Just to follow up, do you have any idea how long this company's been doing this type of work?
Honestly, no, and I would suspect a very long time.
In that case, it could be a $1,000 civil penalty for each year they didn't register.
I think it could. I'd need to do a little bit. I need to look at the rules specifically on that, but I believe that is correct.
Do you think the firm was ever registered with the Secretary of State? Did you look at that?
They didn't really provide any information about who they are or what they do. I don't know much about them other than they're conducting business in a way that does not align with the Vacation Club Act.
Well, at least back to August 2016,
Right.
at least that far.
19, couldn't do 19 yet because it's not July 1st.
Go with what we got.
We could refer them to look into them. Department of Commerce to look into them to see if they're filing, who's not filing on time.
The respondent.
Yes, but other people that are not doing, not only this one, but other
So that's a different issue, but we should
Yeah.
talk about that in just a second. There's been a call for the question. Is anybody opposed to going ahead and voting on the motion? If you are, vote against the call for the question. Or anybody can tell me before we vote, and if there's no issue, we'll go ahead and take the motion on.
3.5 years.
All right, since there's no hesitation, let's go ahead and vote on the motion, which, if passed, would offer this, we're going to call them a vacation lodging firm. What are we going to call them?
Vacation
Club. A $1,000 civil penalty. Miss Hills.
Well, I would like to amend my motion in case number 3, ended in 2571. It says that the complainant's made payments for 3.5 years, too, so that reinforces. So reinforces over 3 years. I'd like to amend my motion to say $1,000 per year.
Times 3.
Yes.
Is there a second to that?
Yes.
Okay, Ms. Taylor seconds the motion. I know parliamentary, we may have been out of order doing this, but the chair is going to say at this moment on the floor is a motion to offer this vacation club a $3,000 civil penalty, $1,000 for each of the 3 years we can document they did not register. Discussion? You guys okay? Questions before we vote, or any guidance you'd like to give us?
The only note that I'll make is because of the date being August 31st, 2016, there was a discussion in legal about whether or not this may be outside the statute of limitations. Typically, it's a 2-year time frame, but because it looks like this isn't a continued unlicensed activity, I believe that it's still proper.
Okay, I'm going to assume we're ready to vote.
I believe so, unless, is there anything else to add into the record?
All right, the motion on the floor, offered by Ms. Hill, seconded by Ms. Taylor, if passed, would offer this vacation club a $3,000 civil penalty, $1,000 for each of the 3 years we can document they have not registered.
Can I amend the motion?
Yes, sir.
I also would like to include an order that they cease and desist from continuing to operate without registration under 6632-134.
All right, without objection, that amendment is added. Any other comments? Are you ready to vote? Let's do it. If you're in favor of the motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. As amended. Number 5.
Number 5 is 2018-085031. Complainant was a prospective purchaser of a piece of land, and respondent was the listing agent. Complainant was not represented in the transaction. Complainant alleges respondent purposefully engaged in false and misleading advertising. Complainant, who lives out of state, found respondent's listing on Craigslist and traveled to Tennessee to view the land. Once at the site, complainant called respondent. Complainant claims respondent instructed them to find the yellow ribbon, which served as the boundary line past the old barn that was falling down to the next yellow ribbon. Respondent denies this version of events and claims they don't have any idea what complainant is talking about. Respondent states they had limited information about the property because it was being sold by someone who recently inherited it and didn't know much about the land. According to respondent, they advised complainant to have a survey done so they could ensure they had the right location and boundary lines. In any event, about a month later, complainant contacted respondent again to make an offer on the property. The transaction was delayed due to probate issues, but the sale eventually closed some 8 months later. Complainant states that after they closed on the property, they drove up to begin installing a driveway. When they arrived at the property, they didn't see any survey flags that they were told would be there, so they called the surveyor. The surveyor came out to meet them and showed them that the property they actually purchased was further down the road. Respondent admits that they accidentally included pictures of a wrong piece of land in the listing, but denies complainant's other assertions and states that they informed complainant about the error with the pictures while the sale was still pending. Respondent states that they encouraged complainant to have a survey done and to review the surveyor's findings prior to closing, and notes that they had more than enough time to discover the misunderstanding since the closing was delayed. Counsel is of the opinion that both parties could have done more to avoid the situation and notes that respondent was not complainant's agent. Ultimately, though, respondent admitted to using the wrong pictures and stated that they really didn't know much about the property prior to listing it. Counsel recommends a letter of warning.
Do we know when they were first licensed? Or just...
They were first licensed. Oh, this is one of those database errors. No, we do not know.
Feel like there's more needed here. There's more than a letter of warning. If he didn't know about his own property that he was listing, that's a major issue to me. That was the agent's responsibility to get that from whatever reasonable skill and care. Plus, what would be the fine on that?
$1,000 max.
$1,000. Okay, that's what I say.
Okay,
Second.
Would you like to be the maker of the motion or the second?
It doesn't matter.
All right.
Make it now second.
Ms. Taylor makes a motion to offer this licensee a civil penalty of $1,000 for failure to exercise reasonable skill and care. Seconded by Mr. McMullen. Further discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 6.
Number 6 is 2018-09-0511. Both complainant and respondent are affiliate brokers. This matter stems from a transaction in which complainant represented the seller and respondent represented the buyer. Complainant alleges violations of the escrow rules, namely Tennessee Comprehensive Rules and Regulations 1260.02-.09. As an initial matter, counsel does not recommend disciplinary action be taken against respondent because the rules expressly place the responsibility of escrow account and funds management with a firm's principal broker. The principal.
Let's just see if we can shortstop this one a little bit. So we can tell right now you're not going to recommend anything against this respondent.
No.
Why don't you read the last paragraph into the record, and we'll see if we can handle it.
As stated above, counsel does not recommend disciplinary action be taken against respondent because the rules expressly place the responsibility of escrow account and funds management with the firm's principal broker. The principal broker is also named as a respondent, and their case is presented immediately below.
Motion to accept counsel's recommendation.
A motion by Ms. Hill, second by Ms. Taylor. The council's recommendation be adopted and this complaint be dismissed. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 7.
Now, the facts of these two complaints are in number 6, so would you like me to read from number 6?
What do you think, Commission?
I read it.
Let's just go with the narrative on 7, and if we have questions, we'll come to those.
Respondent is the principal broker for the buyer's agent, the named respondent in the above complaint. Respondent's answer to the complaint largely reiterates the affiliate broker's statements. As of the drafting of their answer dated January 4th, 2019, respondent stated the escrow funds were being held by the firm and that they should be returned to the buyer. Regardless of whose interpretation of the purchase documents is correct, counsel believes that once it became evident that there is a dispute over the earnest money funds, the proper course of action would have been to file an interpleader. Counsel also believes the disbursement constitutes an additional violation, as it appears to have come from the firm's commissions account. My recommendation is for a $500 civil penalty for the failure to interplead and an additional $1,000 civil penalty for the commingling.
Motion to accept.
Second.
A motion by Mr. Diaz, seconded by Ms. Hills, that council's recommendation be adopted and the respondent be offered a sum of $1,500 in civil penalties. Discussion. So the only thing I don't like about the narrative is it says council believes once it became evident that there was a dispute over the earnest money funds, the proper course of action would have been to file an interpleader. That would be one course of action in my mind, but the statute also allows the broker to make a decision and do something with the money, whether it's right or wrong.
It authorizes them to make disbursements in certain situations, but I believe
Says reasonable care, which reasonable interpretation, which is
right.
big.
But I think the broker has the right to do it. It may not be the smart move when you have interpleader as an option. I'm not arguing with the motion at all. I just want to make sure that the broker has the right to make a decision.
That's true. And that would be my argument.
Broker did make a decision. It might not have been timely.
So it was after the 21 days? Let's see. Let me go back.
So, look at number 6.
November 16th. Raise trumpet and say if he's making that.
My particular issue here was with the fact that, I don't know that you could say that the broker did make a decision. The funds were just being held at the firm. To me, that's not making a call. That's just waiting to see what happens.
Well, but if they made a decision based on who they wrote the check to. No matter which side, it was a decision.
But you can't give escrow funds back to somebody unless
So-
they both agree.
No, you can.
You can.
The law lets you do that. You can. Yeah, you absolutely.
And it's
have-
on the contract, and it matches the statute upon reasonable interpretation.
And
But then it's supposed to, I thought it was supposed to be within 21 days. And after you crest the 21 days, then that's different.
right. The rule says absent a demonstration of a compelling reason, earnest money shall be disbursed, interpleaded, or turned over to an attorney with instructions to interplead within 21 calendar days. And on my review of the complaint, they haven't done anything with the money.
I thought somebody got it back.
They got it back.
And number 7, respondents' answer to the complaint largely reiterates the affiliate broker statements. As of the drafting of their answer, dated January 4th, 2019, respondents stated the escrow funds were being held by the firm, and they believe they should be returned to the buyer, but they're just being held.
Like back up at number 6, the paragraph from the bottom, not the bottom, but the next one up says, in follow-up to the original complaint stated they finally received the earnest money from respondent's firm.
And
Okay,
the $1,000 is for cutting it out of the commission.
It might help
management.
to read number 6.
Let's do it.
Okay. Let's see. I'll just read the whole thing. Both complainant and respondent are affiliate brokers. This matter stems.
Part in the next paragraph.
Okay. On November 16th, 2018, respondent delivered to complainant a notice of termination and earnest money release form. The termination was based upon the home inspection contingency. Complainant states they advised their seller to reject the notice and release request because the inspection period had already expired. The buyer did not appear at the scheduled closing. On the 28th, complainant's client, the seller, provided the buyer with their own earnest money release form, claiming the earnest money as partial damages, and informed the buyer that a court action was pending. Respondent advised complainant that they believed their client acted properly and they would not be releasing the earnest money. According to complainant, on December 7th and again on the 8th, they reached out to ask if a date for an interpleader had been set, but never heard back from respondent. On December 13th, complainant reached out again to ask what was going on with the earnest money. Respondent stated that they already sent a release form to complainant, presumably referring to the initial release form sent on the 16th. Complainant next contacted respondent's principal broker on the 20th, but again never received a response. Respondent does not deny the timeline of events, but believes their client rightfully terminated the purchase agreement and therefore is entitled to keep their earnest money. Respondent acknowledged receiving complainant's inquiries, but states they did not respond until the 13th because of complainant's repeated threats of litigation. In a follow-up to their original complaint, complainant stated on April 2nd, 2019, that they finally received the earnest money from respondent's firm. However, complainant states that the payment came from the firm's commissions account, not their escrow account, and respondent's principal broker provided a copy of the check, which confirms the disbursement came from the commissions account. So those are the facts for numbers 6 and 7. There was not a disbursement until April 2nd, dating back to a transaction that occurred in December.
We have a motion on the floor.
Motion at the moment is to accept council's recommendation. The chair threw up the topic that failure to interplead is not necessarily the reason we ought to offer the $500 civil penalty, because I don't think the contract. I think the statute gives the principal broker the right to interpret, make a reasonable interpretation. But he did it way late, or she did it way late.
Regardless, we're still talking about Part 9 of that rule, right? That he didn't either disperse it, interplead it, or give it to an attorney with instructions to interplead it within 21 days.
Yeah, so that's why I'm not necessarily opposed to the recommendation at all.
Okay.
I just want to make sure what the reason is. Further
The
discussion.
shorthand summary of that rule probably would be better to say failure to do something within 21 days, maybe, or whatever. That's the rule we're talking about, though. Okay.
All right. So the recommendation should be modified. If we accept council's recommendation, you'd recommend that it state the 21 days is.
I'd just say for violation of 1260.02.09.9, and then 1260.02. I think those are both what we're talking about.
Okay. You've heard the motion. You've heard the discussion. Is there further discussion? If not, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. What does the commission think about taking about a 5-minute break and then finishing up?
I think it'd be great.
Let's take 5 minutes.
Number 8 is 2019-001581. Complainant, a property owner, contracted with a licensed real estate firm and property management company where respondent was then affiliated. Respondent is a licensee, and it appears they are still technically affiliated with that firm, but they no longer work there, and their affiliate broker license expired in July 2018. Complainant states that after reaching out to the firm, respondent contacted them to let them know they would be taking photos and advertising the property. Not long after listing the property, respondent contacted complainant with 2 interested tenants. Complainant states they instructed respondent that they did not want any renters with a criminal background, and according to complainant, respondent informed them that the interested tenants had no negative rental or criminal history. The tenants were approved, and complainant states respondent stopped working at the firm shortly thereafter. Eventually, after about 3 years of occupancy and 3 months of non-payment of rent, complainant filed a lawsuit against the tenants for property damage and breach of contract. The tenants failed to appear in court, and complainant received a default judgment in the amount of $14,000. Since then, they have not been able to locate the tenants and discovered that they have other outstanding judgments against them, and that one of them already had a criminal record when they applied to rent the property. Complainant thereafter contacted the firm to ask for the original background checks. According to complainant, they were advised that the tenants weren't qualified at the time of their application, and they never should have been approved. The firm thereafter provided complainant with a refund, and according to complainant, encouraged them to take further action against respondent. Respondent states they no longer work as a real estate broker, but they intentionally left their license with their former firm until it expired so that they could be available to help out as needed. Respondent states they no longer have access to the firm's transaction files and assisted on over 300 leases, so they do not have a specific recollection of this transaction. However, they provided a summary of their standard routine. Respondent states they performed a credit and criminal background check on every tenant who applied for one of their listed properties. Respondent states they screened the applicants and then would review those who were qualified with the property owner, who ultimately approved or disapproved the applicant. Respondent states there is no reason they would have done anything differently in this transaction, and they never received any complaints regarding the other approximate 299 leases they worked on. In rebuttal, complainant states they never received or discussed the tenant's background or credit checks. Since complainant is no longer active in the real estate industry and their license has expired, council recommends a letter of warning regarding a licensee's duties of reasonable skill and care should they ever seek to reinstate their license. And that recommendation, again, is for a letter of warning.
Second.
Have a motion by Ms. Taylor, second by Ms. Hills. The council's recommendation be adopted.
So if they come back to activate their license and we see the letter of warning, what happens?
You would look at that, we'd look at the application more closely. I don't think it would be grounds for having them appear before the commission, but we would have an eye on them unless, I could be wrong about that, and I would know more about appearances, but I don't think this would be enough for an appearance. I don't know that it would necessarily do much for the commission or for whoever will be reviewing their application should they reapply, but it would serve to let them know that, this kind of conduct, if it were to continue, would result in future discipline.
So, just to chime in, 1260-01-.016 states that if an applicant has been, this is for convicted of or found guilty of any felony, or if they've had disciplinary sanctions imposed on them by any local, state, or federal occupational licensing body, then they would fill out the application for a decision. So technically, a letter of warning is considered private discipline, meaning that it's not posted on the disciplinary action report. But typically, when we have someone apply, if they have any disciplinary history in the past, that is something that we would take into consideration. And disciplinary sanctions typically would include consent orders. So not necessarily a letter of warning per se, but if the commission, I think it's within your purview, if you wanted a person that has this letter of warning to appear before applying, that could be something that we could do.
I think they violated 404 and maybe 403 because they didn't obey the instructions of the client, and they weren't loyal to the client, and they didn't exercise reasonable skill and care. And I would want them to have to come back in front of us if they were ever going to try to get active again.
To add on, I would want to know what happened to that $14,000 judgment against them.
Against the tenants, not against the respondent.
I'm sorry.
They didn't
Okay.
get that, I'm sure.
Thank you.
Adding it.
So in order to trigger the provision that you read a second ago, Anna, is it enough that we just find that there was a violation of that, or do we have to impose some sort of penalty on them in addition in order to trigger that provision?
Well, it says disciplinary sanctions imposed. So typically, I think that can vary from jurisdiction to jurisdiction, depending on where. I think it would, if the commission would decide that this is being considered as a disciplinary action that's been imposed by you in the letter of warning, I think that would be something we could flag it on their licensing file, so if they try and reapply. So I think because we can't impose it on them now since their license is expired, so they're technically unlicensed, but if they were to reapply,
Called it a letter of violation and said in the letter that it was a disciplinary action, and we said they violated 404 and 403.
the only thing that might be an issue with that is trying to track that in our system because we don't have letters of violation. So that's not a disciplinary action that we have on any of our commissions. Can you give me a second and can we circle back and I'll figure out what we can do for this one? Sure.
Letter of warning, and there's another letter that's stronger than that, right?
Letter of warning is the stronger letter, so letter of instruction is below it. Let me think about that and get back with everyone.
As soon as they quit talking.
I was thinking we could just send them a consent order seeking their agreement that if they reapply, they will first appear before the commission, but otherwise not imposing any penalties.
That'll work.
That's your motion, Mr. McMullen.
My motion, substitute motion.
Second.
Seconded by Ms. Hills. We'll vote on the substitute motion first. If you're in favor of the motion, vote aye. Aye. If you're opposed, vote no. That motion passes unanimously. So, Kelsey, I couldn't discuss this, but this guy was an affiliate broker with the company, right? Did the company itself respond to the complainant's request for documentation?
No, I don't believe that this complaint was sent to the firm.
Logically, shouldn't the company have the documents? It shouldn't be an affiliate broker that has all the files. They belong to the company.
Mm-hmm. That's who the keeper is.
That's who should be the keeper of the forms.
Yes, the complainant stated that they contacted the company and the company confirmed that there were no background check files, but that, or there was rather, but that the tenants were not qualified. So, I mean, we didn't receive a direct statement from the company, but I think the company is aware and did answer the complainant's questions.
So is your sense they have the files? There
Yes.
just wasn't something in the file?
Yes.
Okay, thanks. Number 9.
Number 9 is 2019-003401. Complainant was a new construction property buyer and respondent was their agent. Complainant alleges respondent failed to represent their best interest when they advised complainant to sign an earnest money release form, which would provide complainant with their earnest money, but allegedly also constituted a waiver of any possible claims that they may have had against the seller for breach of contract. Represented by legal counsel, respondent states the parties' negotiations broke down when the builder refused to provide a particular type of warranty. Respondent states they advised complainant that if they proceeded with the closing without the warranty, they would not be able to sue the builder/developer for any defects in the property. They would receive the property as is. Respondent states at that point complainant insisted on return of the earnest money if they were not going to close on the home. Respondent states they advised complainant of their options and informed them that signing the earnest money release would also act as a waiver of any claims their client might have against the seller developer. Counsel does not necessarily disagree with respondent's advice and representation of complainant, but recommends a letter of warning regarding the prohibition against providing clients with legal advice, and that's under 6213-312B19. The unauthorized practice of law. I'd also like to just add, I really went back and forth over this one, and I particularly like the commission's input because I'm not sure what is typical of an agent to advise their clients. I think any time that you're advising somebody of their legal rights and remedies, to me that looks like the practice of law. But if this is the kind of advice that agents routinely provide their clients, then I don't think there's necessarily an issue.
My opinion. It's only my opinion. If, and I do not know if these were the TR forms, but in the TR forms, that is already printed in.
Especially the disclaimer.
Yeah, it's printed in, and it releases who the parties had signed of any future. It says of any future ramifications. So you don't sign it, and if that's where you want to go, then you don't sign it. But as a broker, we don't disperse anything unless those two parties who have signed and the agents don't sign that until they say the two parties agree what's happening with it, because that's in the instructions as to what is to happen with the earnest money. So then if nobody signs, then it kicks into, can't come to an agreement, it goes to interpleader or something. So it's pre-printed if that's the form that was used.
I'll pull up the form, see if we've got it.
Basically, if the party wants the earnest money back now, then they have to waive claims.
If we use those forms, then we've been told that if you're a member and you use them, you don't just cherry pick what forms. Now, certainly they could have a right to come up to another agreement and write it.
Right.
Anything written then would allow me to disperse the earnest money.
Sure.
I mean, it could be on paper bag.
Or if they can't reach agreement, then you could interplead the money, and they'll have
Yes.
whatever claims they have, and the court can decide it.
It looks like they did use the TR forms. So if that's the case, and yeah, that statement of waiver is on here.
But, I mean,
then
I point them out. I point that section out. That's
Yeah.
why I know it so well. You say this is for any future. It says any future.
I'd like to amend my recommendation to a dismissal.
Motion to accept.
Second.
So, discussion. So I'm going to vote against that motion. So respondent had an attorney respond for the person.
Right.
And inside the response it says, the respondent says they advise complainant of their options. Now that sounds like legal advice to me. Now that's an attorney quoting his client. You would think an attorney would clean that response up a little bit.
That's me paraphrasing the attorney's response. I don't want to quote them as saying my client advised. That's just a word that I used. You can substitute informed for advised if you would like.
So you could say respondent states they inform complainant of their options.
Yes, that would be an accurate statement.
All right, other comments? All right, the motion on the floor is to dismiss. Who made that motion? It's Mr. McMullen, Ms. Hills? Okay. Let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Number 10.
All right, number 10 is a represent. I'll just go to the new information. The legal division encountered numerous difficulties trying to contact respondent, but as of now, respondent is no longer active in the real estate industry. Their firm has been shuttered, and both their principal broker and firm licenses have been revoked. As such, counsel recommends this matter be dismissed.
Motion to accept.
Second.
Motion by Mr. Diaz, second by Ms. Taylor, that council's recommendation be adopted and the respondent be offered a $1,000 civil penalty. Am I on the right?
Or dismiss.
Dismiss.
Oh,
But
we
they-
have new information.
Represent,
But
yeah.
there will be a letter in the file, right?
Yes.
Yes, okay, yes.
Okay, the chair is way off.
No, it's not.
Number 10, okay, motion on the floor is to dismiss. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Number 11.
Number 11, new information.
This also is a represent.
Yes, all of the remaining cases are represents. So the new information on number 11.
Let's just caption this and say it has to do with a real estate course, not
It is an
Instructor.
instructor.
which we never deal with to speak of, except for this one time that I remember.
This is the first instructor complaint that I have seen.
Okay.
So our new information is counsel's proposed consent order was received by respondent's son, who is now acting as respondent's conservator. Respondent is an elderly individual who has recently entered into a conservatorship after suffering cognitive dysfunction following an extended hospital stay. Respondent's son is unfamiliar with Tennessee real estate regulation and was not aware of the complaint brought against respondent. After speaking with respondent's legal counsel, it is evident that respondent is not likely to engage in any further real estate course instruction. Counsel did receive and review respondent's medical records, which conform with their attorney statements, and my recommendation is that this matter be dismissed.
Motion by Mr. Diaz, second by Ms. Taylor. Ms. Hills.
So it says the type of license is Real Estate Commission course instructor. So we license for that?
Yes.
We do.
I can.
We license instructors and not courses.
So I thought we approved.
You approve courses, but once in instructors, but once you receive that, there is a license for an instructor.
So when we approved the instructors today, we were approving their license,
For them to teach, yes.
and so they apply for a license.
They apply to be a course instructor. It's titled as a license. So course instructors, like courses in real estate, in real estate agents expire. So it would be like a license, yes.
Okay. And they have to reapply every 2 years or something. Okay.
The son, the conservator,
Yes.
would he sign a consent order that suspends the license?
I don't know if he would do that, but I can.
You don't think that this respondent's going to be teaching any more classes, do we?
No.
We probably don't really want them teaching any more classes.
No, I don't. I don't think there's any chance that they are going to be teaching anytime in the near or distant future. Let's see, their license is set. It's not set to expire until the end of 2020. So I can reach out. I don't know what they would do, but I can reach out and ask.
I'd like to do just a consent order that suspends the license and see if the son would sign it. And then we don't have to worry about this coming back up again.
Through 2020.
Second.
Or could we do a voluntary surrender instead of a suspension?
We could, I think,
We could
that
offer
would be your
both.
motion.
You could do author either or.
Yeah, my motion would be either one, just get him to agree to one or the other and
I like that.
All right, that's a motion on the floor, seconded by Diane. Is that right? All right, let's vote on the motion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. What I found interesting in that is that council, I guess, you're qualified to review medical records and make sure they conform with.
They could have been fake, but they looked pretty good to me. So.
You didn't look at the words on it; they just look like medical records. Is that what-
To be clear, I am not qualified
I
to
just
review
wanted to-
medical records, but I'm going to take their word for it.
Number 12.
Okay, number 12 is 2018-067111. Our new information is after the Commission's authorization, but before Respondent received the proposed consent order from Council, Respondent dispersed the earnest money funds to complainant pursuant to Rule 1260-02-097A, which authorizes disbursement upon a principal broker's reasonable interpretation of the contract, which authorized them to hold the funds. Council believes Respondent acted prudently and reasonably by consulting with their attorney as soon as the issue developed and prior to taking any action on the escrow funds. Further, complainant has no prior disciplinary history. As such, Council recommends the Commission downgrade the previously authorized civil penalty to no more than a letter of warning. And so my recommendation is really for dismissal, but alternatively, a letter of warning.
Recommendation? Oh, to dismiss.
Your motion is to dismiss per council's recommendation. Is there a second?
Up to speed.
Is there a second? I'm going to say that motion at the moment dies for lack of a second. Mr. McMullen.
Can I ask a question? So, was this a situation where the respondent held the money
Yes.
for a long time, but then
There
maybe
is-
before that they got the consent order, I think you said, or
They
after
went ahead and dispersed it.
they went ahead and dispersed it? Mm-hmm. Which, I mean, I guess it's good that they dispersed it, but there's still the problem that they held it for so long.
They did, but only after consulting with their attorney, who is also a title. They own a title company, and they're their attorney. I can't really come up with any other. I mean, that just to me looks like good, proper conduct. I mean, I'm not sure what else they should have done other than ask their attorney and title company owner, what should I do with the earnest money? The title company attorney recommended holding on to it.
Well,
So
it would
they
have been
took their
good if the
advice.
title company attorney had read our rule that said they got to do something within 21 days.
Right.
So
I
maybe
just-
they got some bad legal advice. Maybe they have a cause of action against their attorney for some bad legal advice they got
I think
there.
they could. I just don't, I think that the disbursement, pursuant to their reasonable interpretation was fine. It was just a little late. I think they were acting reasonably by going with the advice of their title attorney. I'm not sure what else brokers should do if not rely on the advice of title attorneys. Well, other than read the rules, but.
They should read the.
Maybe that was a compelling reason.
Before we vote, this looks like new stuff to me too. Open the decision that's highlighted in black. It said that the requirement that earnest money funds must be removed from the account 7 days after signing the consent order. What does that mean?
Just that the funds should either be interpleaded or dispersed.
Is that inside the consent order? Is that what Commission authorized, or is that this
Yes.
language you include?
That the funds be interpleaded or dispersed or turned over to, like the language from the rule that we cited earlier, that the funds be turned over to an attorney with instructions to interpleaded or dispersed pursuant to reasonable interpretation, but they took action with the funds before they received the consent order.
All this putting a 7-day requirement to get the money out of their account, but I don't recall a lot, so it's very possible. All right, so at the moment, I don't believe we've got a motion on the floor.
I'll make one.
Okay, Mr. McMullen.
My motion is to reaffirm our original decision.
All right, you've heard the motion. Is there a second? Second. All right, Ms. Taylor seconds that motion. So now on the floor is a motion offered by Mr. McMullen, seconded by Ms. Taylor, that if passed, will reaffirm our previous decision on this particular case. Discussion. I sense there's no discussion. I just want to do this. Brianna, let's do a roll call vote on this one.
Get a spike in.
He's going to make sure I wear a wig. That's what he's doing.
Commissioner Jeff Diaz,
I'll vote aye.
Commissioner Rick Douglas,
No.
Commissioner Diane Hills,
Yes.
Commissioner Austin McMullen,
Yes.
Commissioner Fontaine Taylor,
Yes.
Chairman John Grease.
Yes, that motion passes on a 4-aye, 1-no vote. Very good job, Brianna. Thank you for that. All right, Mr. Douglas votes no on that. Let's move to number 13.
Number 13, and I believe this is the last one. Number 13, represent as 2018-048611. New information is an attorney for respondent reached out to legal counsel to clarify some points about respondent's business. Respondent has not nor intends to receive or charge any commission or other consideration from any person with regard to possible real estate transactions, nor do they offer to act on anyone's behalf in real estate transactions. To date, respondent's company has not closed on any sales. Thus far, respondent has done no more than offer to purchase properties for their company. Respondent's counsel countered the commission's authorization of a $1,000 penalty and proposes the entry of a consent order which would mandate that respondent get licensed within a specific time frame. Counsel agrees that this is a suitable remedy as it will automatically place respondent under the jurisdiction and licensing laws of the commission. So my new recommendation would be for a consent order requiring respondent to test and apply for licensure within a reasonable time frame determined by the commission.
Go
So
ahead.
this was opened a year ago, July 24th, 2018.
Yes.
What's a reasonable time?
For getting licensed? I am not extremely familiar with the application process.
Right now, it's taking like 5 to 6 days.
They would have to still test.
Right, I mean, once they did all
Once
that.
they
and then
do
we
it,
received
I mean-
that
Okay.
RN.
Yeah.
I don't know what
I'm just interested in the notion of attorneys negotiating with each other. Is that
That's just how it works. I mean, that's just what attorneys do.
Well, who got the better end of that negotiation, I wonder?
Well, nothing's been decided yet.
That's correct. That's exactly.
About to find
Pull
out.
an Alston and say we need to go back to the original decision, our decision. That's what I would like to do.
The original decision was for a $1,000 civil penalty for unlicensed activity.
Cease and desist.
Right. And
Just
then
combine the two.
That's what I would say.
their attorney's argument is that there hasn't actually been unlicensed activity, but they understand that this does involve real estate, so their offer of compromise was, why don't they just get licensed in that
Yeah,
way?
and you could stretch it and say they're where it says we negotiate and buy short sales, negotiate and buy. I mean, are they practicing law also?
I don't view this as unauthorized practice of law, but also I would note that the attorney did state they haven't actually transacted.
But they're advertising. We have strict
They were
advertising.
They were
rules.
advertising, yes.
I mean, we have strict
So
advertising.
in the original fact set, it says that he's a buyer, but he also brings in investors and buyers as well. Is it out of altruism that he does that? Is he getting a fee for bringing those
I think
buyers
this
and sellers together?
I believe it's investment properties.
And he will do open houses. It says he's not given any open houses.
Right. I don't think, I think that this really boils down to language, and that the use of the phrase open house was a mistake. I don't believe that they were stating, I'm throwing open houses for potential buyers to come in. I think they were
investors,
just
which are buyers.
hosting their investment partners.
So, in my opinion, if they had already done and had the intention to do it, we wouldn't be having this discussion. It would be over. We'd say, okay, did it, thank you very much, and go on. However, they're looking to us to act, so I say we go back to $1,000 civil penalty for unlicensed activity and cease and desist. And I just think it's on their back. That's where my opinion comes from.
The reason, the primary reason that I stated, I think this is a suitable remedy, although that is not my call.
It is.
I think that
but
this
they
is-
haven't taken any action to do it. I think it is very suitable.
Well, I think they fully intend on taking action if the commission agrees. I mean, we'd get a consent order stating that they're going to have this done within X days.
Doesn't say how many days, does it?
Well,
Proposing.
It
no,
says
but
a specified
the
time frame.
commission is more, I think, better suited to come up with a time frame than I is it your sense this individual is going to get licensed Yes.
irregardless of what we do?
I don't know what their intentions are, going forward. If it depends on this, I do know that I think that this is a case where it's one of those businesses that's kind of in a gray area. Are they a real estate firm or are they not? And this individual is stating that they acknowledge that, so they're going to get licensed regardless of if the law says they have to be or not. They're saying, why don't I just get licensed, and that way.
But they've had a year to do so since the complaint was opened.
I agree.
I
Need to get
I wouldn't say they've
on with it.
had a year. They're right. The complaint was opened in July. That means that we received the complaint. It was filed with the commission. It then takes approximately another 3 months before all of the responses come in, and then it gets referred to legal. Then it takes me maybe another 2 or 3 months before I can even get it on the report. So I don't think they've just been sitting around, and some of the time issues is just attributable to our system, not to them just.
But we're supposed to process them within 180 days, right?
That is our goal.
Okay. So that's 6 months.
Right.
So in this individual's attorney's best case situation, this commission would say something like, you've got until September 1st to get licensed, or you owe us $1,000.
Yes.
not owe us, but I mean a civil penalty of
And that's-
$1,000.
Yeah. And
Is that what you think they're looking for?
That's what I would write up in a consent order, that if you're not licensed by this date, then the civil penalty is reinstated.
So we don't really have, if they don't get licensed, we say that was $1,000, but they don't have any, we don't have any leverage other than bad
If they don't
debt.
get licensed, then the civil penalty stands, and if they don't pay it, then we go to a hearing, and then it goes to
But unlicensed, but it's an unlicensed person at that point, right?
they would be unlicensed, but if the commission wanted to move forward with this as unlicensed activity, assuming they didn't sign the consent order, then there would likely be a hearing on the matter.
We don't, now it's an ALJ without us, right, on unlicensed
The
activity.
ALJ is authorized, but it's my understanding that you could still participate in the hearing.
Okay. What do you want to do, Commissioners?
my motion that we, the consent order for $1,000 civil penalty for unlicensed activity and include a cease and desist.
So you want to go back to...
Or they may apply, choose to apply, educate and apply, get their license by September 1st.
I think they've already had so much time.
I do too.
I don't think we need to give them another, we've done this. Get on with it.
And that's why I said
Yeah.
it would have been better, looked at it
Absolutely.
better if they had done it with that intention, done it, and we wouldn't have.
So
been having
let's
this
just to make sure we keep this, the motion that has been made but not yet seconded by
excuse me.
Commissioner Hills is a substitute motion that would revert back, if passed, to the previous decision and give them an and/or be fully licensed by September 1st, 2019. Is that, as I understand, is there a second to that motion?
I'll second it.
Mr. Diaz seconds it. So that's what's on the floor at this time. If this motion fails, the substitute motion fails, we'll go back to Ms. Taylor's motion, which would simply reconfirm or confirm our previous
The
decision.
original.
Yep.
Uh-huh.
Okay?
State the motion, the substitute motion again.
Substitute motion is all two choices. Pick one. Pay the $1,000 civil penalty for unlicensed activity and cease and desist, or have a real estate license in effect by September 1st, 2019.
Got it.
That's the motion. That's the substitute motion. So if you're in favor of that substitute motion, when your name is called by Rihanna, you'll vote aye, and if you're opposed, you'll vote no. All right, let's call the roll.
Jeff Diaz,
Votes aye.
Commissioner Rick Douglas,
Abstain.
Commissioner Diane Hills,
Aye.
Commissioner Austin McMullen,
No.
Commissioner Fontaine Taylor, Chairman John Grease.
What's that total look like?
3, 2, 1.
So I have 3 ayes, 3 twos, 1 abstention. Does the abstention wish to change his vote? Apparently not. Or do you?
I didn't hear what you said.
Would you like to change your vote? Just
No.
Okay. Do you want to change it to no?
No, I want to keep it like it was.
So in the opinion of the chair, that motion passes on a 3-aye, 2-no vote with 1 abstention, Mr. Douglas.
Is that the end?
That it, Ms.
That is
Bridges?
the end.
So, speaking on behalf of myself only, thanks for the work you do to put all this together. If you're only doing if you're doing twice the work than you should, then you ought to get twice the praise. Good job. Thank you.
Thank you.
We appreciate it. All right, anything else from legal today?
That doesn't need to be on the record, though.
Ms. Womack, thank you for your good job today. Thanks. Aaron, you don't have any new news for us yet, right? Can we put you in charge of letting us know when you have new news? Please do. Mr. Douglas.
Yes, I know Ross is not here now, but just as a point of discussion and or an observation, is when I look at the Principles of Real Estate course, which I know is taught in several different modalities, right? It covers a lot of the things that the lady was going to be teaching, number 24 through 27, I think it was earlier that we looked at. Matter of fact, just kind of going down through here, looking at the things that the Principles of Real Estate course covers is licensing laws, rights and interests in real estate, forms of ownership, contract law, fair housing, which was one of the things on that list, I think, taxes. All of these things are covered in Principles of Real Estate, and I've never seen those taught by an attorney. So just kind of wanted to point that out as an observation, that that's a course that every agent has to take, or a prospective agent has to take, and rarely, if ever, are they taught by an attorney.
So do you want to do something about it, about our previous action? You want to put it on the agenda for next month?
Yeah, let's do that.
Move
Put
to
it on the agenda
reconsider.
for next month. Can we do that?
Sure. It's certainly up to you.
Okay.
So those were courses 24, 25, and 26. The courses.
Oh, no, we got.
We
No, the
approved
instructor.
one of them.
It was we
Yeah.
improved the courses, but we didn't
Twenty.
approve the instructor to teach 24, 25, and 26.
Right.
So we'd like to add that back to the agenda for next month. That we'll reconsider, what's her name, Moulton?
Consider
Miss
Jill.
Malloy.
What was it?
We're reconsidering Jill Malloy for
Right.
J24, J25, and J26.
That's it.
Okay?
That back on the agenda. Anything else, Rick?
No, sir. Thank you.
Mr. McMullen? No. Mr. McMullen, later today, will be representing the commission in front of TERS Real Estate Summit, and we appreciate you doing that, and know that you won't embarrass us like some other members of this commission might. Speaking for myself at this point.
I know you're talking about me.
You
No,
might
I'm not.
not quite to such a degree.
Well, I
So-
am planning to go, but I'm not going to be in a representative capacity. Although I will.
You'll be an attorney.
No, I'm not. I'm not representing you all.
I understand.
Although I will certainly bring greetings and
Please,
love.
please do that. All right, Ms. Taylor, any comments?
No, thank you for getting us out so early.
Well, I ain't gonna
Appreciate
give it to
that.
legal, man.
I will.
Yeah, you guys
The
did
last two
great.
meetings have gone really fast, and we appreciate whatever you all are doing to get it there. Thank you.
Mr. Diaz? Hey, Mr. Douglas, let me go back to you for a second. Are you going to watch a video on the way home again today?
He will drive safely.
Lord, give us safe travels on the way home today, please.
He will comply with all roads
Just
and rules of the
checking.
road.
Just checking. All right, Diane, any comments?
Thank you. As always, Mr. Chairman, job well done. Thank you.
Thank you. And on behalf of all the commission, I'm about 95% sure Caitlin is watching this as a streaming video.
She
hope
is.
not.
It's helping her.
I'm
It's
thinking
helping
that's
her
just probably making her morning more comfortable just watching this, I would think.
contract.
In any case, we all wish her the best of luck and newfound success and happiness with her new baby boy or girl, whichever it may be. With that said, we are adjourned.